You're watching Behind the Headlines. I'm Pacchia. Earlier this month, the Bipartisan Policy Center released a report from their Financial Regulatory Reform Initiative's Failure Resolution Working Group on how to craft a solution to the too big to fail problem. It's a large document, but it's really packed with a ton of ideas on the way forward. Joining me now is the co-chair for the task force responsible for the report, Randall Guynn, head of the Financial Institutions Group at law firm Davis Polk. Welcome. Thanks for joining us today. So, this is a mammoth undertaking. How did you get roped into this gigantic project?
Well, I think the Bipartisan Policy Center first asked John Bavenzi to be a chair, and I think he recommended me, and then I recommended that we add Tom Jackson because he's the author of Chapter 14 of the Bankruptcy Code.
Right, and we had this 120 to 140 page report that came out about a week ago. What's the main takeaway? When you look at this stack of papers, is there a singular concept that emerges from it?
Well, I think the main thing is that the key to resolving these large, complex institutions is to have a pre-announced, predictable, and viable strategy to recapitalize the institutions very fast, like over a weekend.
Mm-hmm. So let's talk about the idea that Dodd-Frank fix is too big to fail. It's a controversial statement. Some people, we had Raj Cohen on the program a couple weeks back explaining very precisely how that happens. This is more about presenting lawmakers better choices rather than just the kind of diametrically opposed, either you save this institution or you destroy the economy. Isn't that right?
Yeah, I mean, the thing is that if the only two choices they think they have is a bailout or a collapse of the financial system, they'll probably choose bailout. So in order to solve the too big to fail problem, you have to give them a third choice that they think is a better choice than those. And I think that the Dodd-Frank Act does give them a choice, at least as it's been implemented or proposed to be implemented by the FDIC.
Just for our viewers who might not be aware of what's in this report, can you walk us through the OLA briefly, the Orderly Liquidation Authority on Dodd-Frank?
Yeah, so the Orderly Liquidation Authority is a special authority that allows the FDIC to wind down or reorganize a systemically important financial institution if the Treasury Secretary decides that the Bankruptcy Code won't work well. If the Bankruptcy Code will work well, then there's no such authority. But then if the FDIC, if it's invoked and the FDIC is appointed receiver, what the FDIC has said it will do is to implement that in a way that will do one of these high-speed recapitalizations.
So we're basically building a resolution system that relies on the FDIC rather than the judiciary in fixing essentially a broken bank. The relationship between the OLA and the Bankruptcy Code is really fascinating. One could look at the situation and say, well, look, banks are companies just like any other. Why don't the wind down provisions that OLA came up with, why don't we just amend the Bankruptcy Code and put them in there?
Well, it's interesting. First of all, we have to distinguish between banks and non-bank financial institutions like the holding companies of banks. OLA does not apply to the banks themselves. There's a special resolution provision for that the FDIC has been in charge of since 1933 and will continue to be. What the OLA is for the group. In other words, a bank is usually part of a group, and so it's a process to either the Bankruptcy Code or the OLA will resolve the holding company and other financial institution affiliates of a bank.
But aren't there concerns that the current process outlined in the OLA is somewhat less predictable and a lot less transparent to the process that unfolds every day in bankruptcy courts all around the country? I think some people are having a hard time getting their heads around the concept of, I mean, I've heard this FDIC process be referred to as a star chamber by other interested parties.
Yeah,
How do you get around that?
I think I was actually the first one to use that reference.
You're going to claim credit? Okay.
But it's potentially that. But you're right. The OLA grants the FDIC a broad amount of power and discretion, and that's both the good and the bad of the OLA. So they have a lot of power to correct the problem, but now what they need to do is they need to identify how they're actually going to use it, issue a policy statement or regulation saying, here's how we'll use it for these types of institutions so that the market can rely on it and it can be predictable and will solve the problem. If they don't actually do that, it won't solve the too big to fail problem.
Do you have much insight into the process by which the decisions are ultimately going to get made, whether a troubled institution goes into the OLA wind down process or into bankruptcy court? I mean, I know we know who's going to be making those decisions. Do we have a good idea of what they're going to take into account as they make those decisions? I mean, it sounds like a really difficult call to make?
Yeah, so there's a whole litany of conditions or findings that the Secretary of Treasury has to make in order to invoke OLA. The most important one, though, I think, is that they decide that if they allow the institution to be wound down under the Bankruptcy Code, that it will actually destabilize the financial system, and that using the OLA will avoid that bad result. And so that's the main thing that they have to do. What that then comes to a very important point in this report, which is if we can improve the Bankruptcy Code, we can actually reduce the need for OLA.
That's right. I mean, you guys were basically calling for amendments to be made to the Bankruptcy Code. Two questions there. What is the likelihood that Congress is going to be able to do that? And if they can, what specifically does the Bankruptcy Code need to have changed?
Well, it's interesting. What the Bankruptcy Code needs, you could probably execute one of these single point of entry resolution strategies that the FDIC came up with under the existing Bankruptcy Code. But there are things you would probably amend to the code to make that more possible. And then if for some reason you needed to put the operating subsidiaries into bankruptcy, there are things that you would amend to make it better for that.
So just hypothetically looking at how these potential scenarios might play out, jilted creditors under the OLA as it stands today, can they appeal decisions made?
Well, you talk about jilted creditors. I mean, the fact of the matter is that, say, bondholders, if they're subordinate, they should be assuming that they're bearing the risk of loss if the institution goes under. One of the mistakes, I think, made in the last financial crisis, or maybe the authorities felt they had no choice, but the long-term creditors and even subordinate creditors in a lot of cases were actually bailed out and were sort of guaranteed against losses. That is not an expectation that they should have, and we should be imposing the losses on the private sector instead of the taxpayer.
So we have this 35,000-foot analysis of what Dodd-Frank does in order to get rid of too big to fail. At the end of the day, how close do you think it comes to what's needed?
Well, I actually think, at least as the FDIC has, the powers are there, and I think as the FDIC has outlined it, I think if they use their authorities properly, I think it should actually allow all of the largest U.S. Systemically important banks to be recapitalized quickly and resolved without causing a meltdown of the financial system. And that gets to the point, in order for this to work, they actually have to have enough loss-absorbing resources in the form of common equity, preferred equity, subordinated debt, long-term debt. And the question is, do they have enough of it now? And I think some of the early evaluations of that suggest that they do probably have enough now. It's just during the financial crisis, people were reluctant or didn't think they had the legal tools to actually impose the losses on the subordinated debt or senior debt.
Right. Well, that begs the question. You've been looking at this space for a long time now. How many large financial institutions out there, in your estimation, would qualify as too big to fail, just in terms of size and importance to the broader economy?
Well, I think the Financial Stability Board has identified a bunch of institutions as so-called global SIFIs, G-SIFIs, and there are eight of them in the United States. And I think all 8 have enough loss-absorbing resources now to absorb the losses and be fully recapitalized if we had financial crises that were actually more severe than 2008 or the Great Depression.
Do those calculations take into account net exposure to derivatives?
Yeah, so on derivatives, first of all, what's interesting is the FDIC's approach actually avoids the really serious problems with derivatives, because the problem that people look at with Lehman, for instance, was that the derivatives were closed out and liquidated, and then the collateral was dumped on the market, and that caused the prices of those assets that were pledged as collateral to plummet. And with the FDIC single point of entry, you don't actually close the bank or the broker-dealer, you keep it open, and so there would be no trigger to close out those derivatives. So in fact, the derivatives would stay intact and just live out their life.
What's next in this process? I mean, we have this report now. We have a clearer understanding of what the orderly wind-down authority is going to be at the end of the day. In terms of getting rid of this problem from American society, too big to fail, that is, what's next?
Well, there are 2 things I think that are next. First, the FDIC needs to issue a policy statement really spelling out how it's going to use its authority. It's nice to have speeches. It's nice to have editorials, but they need to have something that's more binding on them, saying here's how we're going to use it so that the market can rely on it. The second thing is the Federal Reserve has been working on and is likely to propose by the end of the summer, they've said, some sort of requirement of minimum loss-absorbing resources that would be a combination of common equity, preferred equity, subordinated debt, and long-term senior debt.
Good stuff, Randy. Thanks for stopping by.
Thanks. Okay.
That's Randall Guynn, partner at the law firm Davis Polk. If you'd like to learn more about the issues we just discussed, be sure to go check out our offerings on BloombergLaw.com and also on the Bloomberg Terminal. You can see more of our videos on YouTube, and you can follow our updates, of course, on Twitter. I'm Lee Pacchia. Thanks for watching.